For this panel, we will have 5-minute rounds of questions after the witnesses' testimonies. Ms. Clark, you may begin.
Chairman Johnson, Ranking Member Issa, and members of the subcommittee, good morning. My name is Caitlin Clark, and I appreciate the opportunity to testify at this subcommittee hearing on protecting workplace rights for judiciary employees. At the outset, I'd like to emphasize that I am not here today to personally attack anyone I worked with in chambers. I am here to describe my experience clerking in the judiciary as an expectant mother. My sole purpose is to shed light on the inadequate protections for judiciary employees. The current protections failed me. I do not want them to fail others. In July 2019, I began what I thought would be a 2-year term clerkship for Judge C. Ashley Royal, a senior U.S. District Court judge for the Middle District of Georgia. During the first 6 months of my clerkship, I built great relationships with Judge Royal's staff, including his career clerk, who had worked for the judge for more than 15 years. She seemed to think very highly of my work, and I looked up to her as a mentor and a friend. By November 2019, Judge Royal offered to extend my clerkship for an additional 2 years, and by January 2020, I received a performance-based raise. But when I became pregnant with my second child, my hopes of building a career in the judiciary fell apart. After I announced my pregnancy to my colleagues in chambers, the career clerk's treatment of me changed. She became hypercritical of my writing, providing excessive and often contradictory feedback, which made it difficult to complete my work. If I asked her a question about her edits, she would belittle and berate me about the quality of my writing until I was reduced to tears. She never did any of this before I was pregnant. In early April 2020, a few weeks into the pandemic lockdown, Judge Royal called me to his house, which he had never done before. He expressed frustration about the pace of my work and brought up my pregnancy. I remember him saying something along the lines of, "While clerking may be a good mommy job, work still has to be done." Later that same day, I called the career clerk to discuss a motion I was drafting. She grew impatient, raised her voice, and said, "It's infuriating to me. I mean, you're pregnant." I remember that word, infuriating. She complained that my new baby was going to ruin her ability to enjoy her son's senior year of high school. I reported this conversation to Judge Royal the very next day, but he saw no need to intervene. And because clerks lack standard workplace protections under Title VII, I had nowhere else to turn. 2 months later, Judge Royal revoked the additional 2-year offer that he had made in November. Then, just 10 days before my daughter was born, he told me to clear out my office. Once my maternity leave ended, I would be terminated. I was shocked. I felt wronged. I had no recourse. At the time, there was no mechanism for me to file a complaint. In the days after my daughter was born, while I was, of course, overjoyed at her arrival, my wrongful termination and treatment in chambers was weighing on me. Fortunately, a few weeks later, the Middle District of Georgia partially adopted the Model Employee Dispute Resolution, or EDR plan, and allowed clerks to file misconduct complaints. But I quickly discovered this system was broken. Pursuant to the plan, I first submitted a request for assisted resolution seeking reinstatement to a comparable position and a positive letter of recommendation. Judge Clay D. Land, who had served on the bench with Judge Royal for nearly 20 years, reviewed my request. His final 2-page report stated that my claims could not be resolved to my satisfaction and a resolution could not be reached. I then filed a 23-page formal complaint alleging unlawful harassment, retaliation, and discrimination. Judge Randall Hall, the Chief Judge of the Southern District of Georgia, adjudicated my complaint. Like Judge Land, Judge Hall and Judge Royal are colleagues with nearly identical backgrounds. They have no incentive to police each other. I did not stand a chance in this forum either. I was denied the opportunity to conduct any discovery, cross-examine witnesses, or participate in a hearing. Unsurprisingly, Judge Hall ruled against me and found I had no claim. I then had 30 days to appeal the decision. On the day of the deadline, the EDR coordinator told me that, unlike all of my earlier filings, my appeal had to be submitted in person. This was in July 2021, during the height of COVID. Determined to keep fighting, I drove 3 hours to Atlanta with my newborn and toddler in the car and filed the appeal with minutes to spare. Just this morning, nearly 8 months later, the 11th Circuit affirmed the decision denying my claim. This decision is final. The EDR process is severely flawed. Law clerks are denied basic procedural protections and the independent evaluation that employees in virtually any other sector receive. Judges are left in charge of policing their own colleagues, allowing their conscious or unconscious biases to affect their decision. This stacks the deck against law clerks who are already extremely reluctant to speak out regarding misconduct given the power and influence of federal judges. Challenging a sitting federal judge and potentially ruining one's career is simply not worth the risk. I urge Congress to reform the system to allow for basic procedural fairness, to eliminate the self-regulation of the judiciary, to guarantee federal judiciary employees Title VII protections, and to protect those who speak out against discrimination from the threat of retaliation. Thank you.
Thank you. To my colleagues, I do want to acknowledge that those who will be giving testimony will be given a little time to be able to finish. I think you should know that out of courtesy to the victimization that they have experienced. So thank you very much for your understanding.